Welcome to the chilly February 23rd, 2026 meeting of the City of Asheville Board of Adjustment. My name is Suzanne Godsey, and I am chair of this board. The Board of Adjustment is a quasi-judicial body that is governed by the North Carolina General Statutes and the city's Unified Development Ordinance. We are authorized to hear requests for variances from the city's UDO, appeals from final determinations made by city officials charged with enforcement of the city's UDO, requests for reasonable accommodations, and other requests as may be provided in the city's ordinances. Our first agenda item is the review and adoption of the minutes and the findings of fact and conclusions of law of the November 24th, 2025 regular meeting. Is there a motion to approve those?
Motion to approve.
Second.
Great. All in favor, say aye.
Aye.
Aye. Our second agenda item is the review and approval of the new Board of Adjustment Rules of Procedure. Again, item 2 is the review of the new Board of Adjustment Rules of Procedure. Did everyone have a chance to take a look at those and have any questions?
I did. I had one question.
Okay.
Or I had one issue. There was, I noticed in most places, the reference to a board secretary had been replaced by staff liaison. Mm-hmm. It looked, as I went through it, it looked like there were some places where that one got missed. My recommendation would be, like, go back and double check. Perhaps it was an oversight, perhaps it was intentional, I couldn't tell. Just pointing it out.
It was intentional, and is Aspen here? I'm going to glare at him. Our planning techs are too talented, they always leave us. This will actually be Aspen Johnston's last as board secretary. We had removed that in a lot of places just so we can have more staff flexibility because those are interchanged a lot. We're hiring planning techs on a near permanent basis because we're too good at our hiring. Gotcha. So they go up and above and onto other things. So that is one of those where we've got that out.
Very good. Other than that, I didn't have anything substantive.
Okay, great. So is there a motion to approve?
I'll motion to approve.
Second.
Second.
All in favor, say aye. Aye.
Aye.
Our third agenda item is to elect a new vice chair for the Board of Adjustment. Does anyone want to nominate themselves or someone else?
I'll nominate Mr. Warnall.
Great. Is there a second to nominate Mr. Warnall?
I second the motion.
Okay, all in favor say aye.
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 Thank you for not resisting your inevitable fate. We now begin the evidentiary hearings for the cases listed on the agenda. In hearing cases, the board conducts a quasi-judicial evidentiary hearing. That means it is like a court hearing. State law sets specific procedures and rules concerning how this board must make its decisions. These rules are different from some other types of land use decisions, like rezoning cases, which are legislative in nature. This board's decisions are constrained by the standards and the city's ordinance and the facts presented at the hearing. The board hears and considers evidence presented at the hearing and applies the standards set forth in state law and the city's ordinance. The board must base its decisions upon competent material and substantial evidence presented at the hearing. If you'll be speaking as a witness, please focus on facts and standards, not personal preference or opinion. Participation is limited. This meeting is open to the public. Everyone is welcome to watch. Parties have rights to participate fully. Parties may present evidence, call witnesses, and make legal arguments. Witnesses may testify as to facts to which they are competent to testify, so long as those facts relate to the legal standards. In addition, lay or non-expert witness testimony is limited to facts, not opinions. For certain topics, this board needs to hear opinion testimony from expert witnesses. These topics include projections about impact on property values and projections about impacts on traffic safety. For variances, a 4/5 vote of the board is required to grant the variance. For all other hearings and matters, including the adoption of the minutes, the decision will be made by a simple majority vote of the board. Witnesses must swear or affirm their testimony. At this time, we'll administer the oath for all individuals who intend to provide witness testimony today. Please stand and raise your right hand if you plan to provide testimony. Do you solemnly swear or affirm that the evidence you shall give to the board in this action shall be the truth, the whole truth, and nothing but the truth?
Yes.
Great, thank you so much. Our first application today is a flood variance, and the applicant, Chris Reno, is requesting variances to the standards in Section 712-1E2B, flood hazard reduction of the UDO. The purpose of the request is to allow for the repair of a historic structure without fully complying with the flood protection standards in order to preserve its historic character. The property is known as 30 Lodge Street and has a PIN number of 9648-60-7352. Sam Starbaum, Urban Planner 3, will be presenting this morning.
Yes, thank you, Madam Chair, and congratulations to our new Vice Chair. I am Sam Starbaum. I am a Planner 3. I work for the Planning and Urban Design Department, and this will seem familiar to you. You have done quite a few of these presentations already and quite a few flood variances. I've kept this same format. I would ask for your patience and understanding. I think it is important not just for the board to know this, but for the community to see this every time about how we did our math to get here, what this is, and why we're doing this the way we are. So this is, even though you are well-versed experts at this point, I think it is still important to start from the first step in our journey. So again, what is a flood variance and when is it required? It is required when the over 50% of the building was damaged in a flood, right? And what would it cost to repair it to the day prior to the storm? We're not talking about a new Costco. We're not talking about some other greater improvement. Is what did it look like the night before the storm in September, in Helene in this case. So when it is 50% damage and above, it is then substantially damaged, and then they are required to come into compliance with FEMA standards. Obviously, in doing that, it raises some concerns in historic districts because it impacts the historic character. So you are allowed to seek a variance, a flood variance in this case, to meet those FEMA standards to the extent practicable, not exactly, but to your best ability to meet those flood proofing standards without impacting that historic character. And that is what we have before us today with 30 Lodge Street. So here's some simple math for you. What we do have is that bottom number, which is the building value according to the assessor's report. It is entirely possible that the Wayside Bar and Grill is worth way more than that in a private appraisal, but what we are using here is Buncombe County figures. And what Chris Reno, the applicant, has determined is that it would cost $179,000 to repair that building to what it was just before the storm. That's 78.7%. That's, of course, greater than 50, so this is substantially damaged. They now have to comply with these standards. Again, I want to be clear, there are instances in which even if you are under that 50%, you can still seek that flood variance. We are seeing a lot of people do that simply because variances run with the land, and this gives them the chance to preserve the historic character throughout future flooding events. 2 through 6 Brook Street, there's been a couple others that this board has seen recently related to Helene. Those are all ones that were beneath that substantial damage threshold, but went forward anyways, again, to meet the maximum extent possible without impacting that historic character. And so these are the same standards for granting a flood variance. In a normal zoning variance, you have 4 statutory standards. There are others involved here. I think most importantly to note is item B, that no development permit has been approved. So this is one of those reasons why it has taken some buildings longer than others to come back in the Biltmore Village Historic District and areas of the River Arts District, simply because, not by our standard, but by federal law, there can't be any development permit. Of course, we can issue these other demo permits, some small trade permits, things like that. But these are the standards that you will be evaluating this flood variance by. Staff can confirm that no development permit has been approved as of yet. And Chris Reno has been willing to go through all these processes. He has also worked with Alex Cole, our historic preservation planner, to get all the appropriate documentation there. Just some more information about the property, and then there are also those 4 standards at the bottom under number 4 that you also have to guarantee. So where are we? We are, of course, in the Biltmore Village Historic District. Many of you who have been around for a while know this is the Wayside. It's the bar and grill. That is right on Lodge Street, just sort of before that becomes Sweeten Creek. You can see that property. It is a smaller property. To the far left of the screen, you can see the entrance to the Biltmore, And then just north of that, you can see the Swananoa River, which crested tremendously, and that's the source of a lot of the damage for this building here on Lodge and in most of the Biltmore Village Historic District. So the aerial photo and the zoning map, most of this is either CB1 or CB2 in the Village District. That's exactly what's happening here. The use is wholly and totally appropriate for the area and has been for some time. There's a long-standing operation there, and this is our flood map. You can see that this is the base flood elevation of 1,999.5, which is common for this sort of area. Again, there are instances where if you are going to meet flood standards, you then have to regulate 2 feet above base flood elevation. Sometimes that is also much higher than the building will get to that and what is required by utilities and by FEMA a little bit later, but that's what that looks like. Here is this great example of what the building looks like, and I think if I could stress both to the board and to the community, this is so important to understand, and this is a great building to look at for this. Duke Power utilities have to be raised above certain flood regulations. At this point, it would be above this 1-story building. So what you would have to do is build in essence, a mezzanine, a parapet, just to support AC, power, things like that. And that would impact historic character. We know that from our guidelines. We know that from best planning practices. We know that from our historic preservation planner. So you cannot, when people are trying to understand the nuance of this is a perfect textbook example, because again, your utilities would go above the roof. That is not just not historic or anachronistic with the building of the time. It's just bad aesthetic architectural practice. So that's what brings us before you today. Again, most of this has already been worked out in that Chris Reno is already working with Alex Cole and with Nancy Watford for flood reporting, for damages, for tracking, for obtaining CA for minor and major works. But in essence, this building is just going to be renoed to what it would have been the day before the storm. I think there is still some private internal discussion whether or not this will continue to be the Wayside Bar and Grill or some other restaurant. Mr. Reno couldn't join us today, but this is your cut and dry flood variance for 30 Lodge Street, and I would be happy to answer any specifics about this if you have any questions. Thank you.
Are there any questions for Sam? Pretty cut and dry. And so you said the applicant's not here today?
Correct.
Is there anyone else that has additional information for this property? No? Okay. So anyone from the public that would like to give expert testimony or testimony from residents with standing? Seeing none. Okay, board, is there any discussion or should we just move to a motion?
I'm ready to move.
You would like to make the motion?
Suzanne, I've got a question.
Okay, please.
Yes, sir.
Hey, Sam, when you're talking about the power coming in, what is the resolution? Are you going to be working on it? I was a little unclear on that.
So because they're going to have to raise electrical panels and HVAC, they would have to basically build something to go above that flood elevation amount, which is higher than the roof line. So what this is this flood variance to ensure that they can raise it to the maximum extent possible without having to build a structure taller than the primary structure. And then there are other things that this does not absolve them from all flood proofing. There are still things they have to do, right? So there are materials you can use on the inside that are more flood resistant, but generally brick buildings and older buildings did better anyways. So there's still ways where they can do pass-throughs, things like that.
Are you okay with that? Yeah. Okay, great.
Motion to approve the variance in accordance with the staff conditions as presented here before the board on slide 11.
I'll second.
Great. Board members, when I say your name, please say aye or nay. James Warnall,
Aye.
John Michael Cletus,
Aye.
Mike Luciano,
Aye.
Suzanne Godsey is an aye.
Yeah, you have to have a unanimous vote.
Yeah, I know.
Today.
Should we inform the future applicants?
Yeah, and we're in the process of that now, you just don't see that on the,
Okay.
that's what I'm frantically typing about.
Okay, our second item on the agenda is an administrative appeal. And do we have any information about that, or is that one moving forward today?
I will let Mr. Sword speak to that.
Good morning, everyone. My name is Jesse Swords. I'm a land use attorney with Allen, Stahl, and Kilbourne. We represent the applicant in this matter. We talked with the city last week, and we actually have a proposed order staying proceedings for this administrative appeal. I have a copy here signed by myself and Ms. Gillingham. May I approach to give it to you? She has a copy as well that has signatures, just so. Essentially, this is similar to what we did with the 17 North Market Street appeal, and I think the city has done it for some other appeals recently as well. We're basically asking for the matter to be stayed, which means instead of, coming and asking for a continuance every month, we will let you know if it needs to be heard, and it will be renoticed, and then it will get on the agenda wherever it falls based on when we notice it. So,
The city has no objection to the continuance.
Okay, great. So with it being a stay versus a continuation, do we need, as a board, need to make a motion to approve so that I can sign this, or?
Yes, I would say make a motion as a board to approve the order continuing this matter,
order to stay this matter.
staying this matter. Since we're not continuing it to a date certain, it's sort of like the last administrative appeal that was heard, the 17 North Market. This board stayed that kind of indefinitely while we worked on getting a date certain for that. So that's what the motion would be.
Okay, so I'm looking for a motion to approve the order staying this appeal.
Motion to approve the order to stay the appeal.
Second.
Great. Do we need to go person by person for this, or is it all in favor?
I'd be safe on this one. Go person by person.
Okay, great. When I say your name, please say aye or nay. James Warnall,
Aye.
John Michael Cletus,
Aye.
Mike Luciano,
Aye.
Suzanne Godsey is an aye. And with that, I'll sign this. Go ahead.
Thank you very much.
We're going to make copies and get one to her and then to Carly, so yeah.
Thanks, Jesse.
Thank you very much.
Thank you, Mr. Swords.
So just to be clear, if anyone is here for the New Hawk Creek hearing, that matter is not proceeding today.
And that stay is for both appeals, so they run together, so we can skip forward. Fantastic. Moving on to our next agenda item is a variance. The petitioner Meredith Bridges is requesting a variance or variances to aquatic buffer standards in section 712-2E2A, erosion prevention and sediment control, and section 712-2F3A, aquatic buffers post-construction of the Unified Development Ordinance. The applicant is seeking to encroach 13 feet into the 30-foot aquatic buffer, and the property is known as 1 Norfolk Street with PIN number 9648-649286, and Tyler Kelly, Urban Planner 2, is presenting.
Good morning. Tyler Kelly, Urban Planner 2, Planning Urban Design. This is the third time we're looking at this property. Meredith has chosen to keep the existing home and just place an addition You can see here in this corner. So the section outlined in red would be the permanent impact to the aquatic buffer, which is a reduced impact to the aquatic buffer from the previously approved variance. So I believe it's around a net, around 50% less impact than the one that was approved, I believe, back in July of 2025. So just as a refresher, I'll let you see. This was the approved variance, or sorry, one more. So we had
Tyler, will you zoom out a little bit?
yes, sorry. This would be with the existing home demolished and then pushing much further into the aquatic buffer to give them a little bit of a larger building footprint. So using the existing home, it's a net reduction of the impact. And I don't think Meredith is here. Let's see here. And just as a little bit of some context, I believe everyone was here previously, but the lot does stretch into the street, so it's already small, it's non-conforming. There's little to no room. The house is already pushed up, basically with like a 3-foot setback, 3.5-foot setback. That would be the bearing for the hardship. Well, we can go over any.
If the variance is less than what was before, what is the addition that's making them come back? I might be a little
I
bit
think
confused.
I'm not 100%. I mean, I think that it's because the conditions of the site have changed. So they're using the existing home rather than building new.
So there was language in the previous variance that spoke to.
I think we
house
just
being
wanted to
removed.
get it back in front of you guys just to, make everything, check all the boxes as far as the reduced impact. And then just a couple of, updated items on the site plan is like the placement of the shed here. And the condition for that to be, moved back into
But
the new
that's-
location.
That's not part of the variance request.
No, it's not, but we're just updating you, essentially.
Yeah, okay. My only fear for this applicant is if something goes awry and they really needed more of that encroachment, they've lost it because they've reduced their variance request.
Correct.
And they're not here, so I guess they're comfortable with that. Does anybody else have questions for Tyler?
I do.
Okay.
Comments. So the 2025 variance was for the applicant to put a 512 square foot ADU on that lot where we see right now it says building with a deck. It was in that vicinity. So this variance is, which appears to never have been, they didn't do it.
Yeah.
So now they're proposing to making it like an addition onto the house, I guess, as opposed to that. Right now, where on the left side of the screen, where sort of in the middle there, it says building with a deck. Their plan, it appears, and based on the words there, they're going to remove that and then slide that shed over to the right side by the road. Tyler, question for you. On page 8 of this packet, where the variance request table is, right there,
it says applicant request, encroachment of 303.51 square feet. However, my question to you is, in the picture on page 7, it looks like it says 140 square feet. So I'm confused, what is 305 versus 140?
I think that's a mistake on my part, just keeping that old data from the previous staff report in there.
Okay, so it's for 140.
Right, so it'd
140
be a
is right.
basic 50% reduction
And then
around there.
also, moving down on page 9 in the background section, so the third paragraph down that starts with the applicant proposes the construction and reads a single-family dwelling with a 512 square foot footprint. That would also be perhaps
That's
not-
incorrect as well. Yeah, it's the existing home. So no new construction.
with the addition on the existing home would be new construction, right?
That's correct.
Okay, so that's what the variance is for.
Yes, and the new variance is for the 188 square foot addition, but only 140, we'll go back up to the breakdown here, 140.3 square feet is going to be the permanent disturbance within the aquatic buffer. And I wish Meredith was here because I think she could give you a little bit more context about the case and why they come back again, but she has not shown.
So these aquatic and buffering standards are those, as I recall, without pulling the UDO up, EPA-related standards for protection of the creek, right?
So I believe that our, Nancy might be able to speak to this a little bit more, but I believe that our ordinance is in some sort of synchronicity with state requirements, but this would be a modification to city requirements.
The only thing I'm getting at is I know, or I believe that the UDO prohibits us from granting a variance to those standards identified in 711(1) of the UDO, as long as this proposed construction is not going to have anything to do with those buffering and those standards. The confirmation of that would be helpful for me.
Do you, yeah.
Landscape and buffering standards.
This is a separate,
No factor?
no factor.
Thank you very much.
Okay, yeah.
Thank you very much. Thank you.
If you ever want the 8-hour answer, come find me and we can get real in the nuance. I do want to be clear. I think there are a couple of things here that do need to be clarified that you have now just provided an open window of opportunity for. This is not in accordance with EPA. This is all for working with the state. These are state standards. This is, here is one of the reasons why this is before you is Meredith had alluded to this being a value engineering factor as to why they're not building a new structure. They're just doing an add-on that seemed to be the most economical thing with the rising costs of all matters. We being the royal we, so Nancy has to do what is called MS4 reporting, which is looking at disturbances, impervious, pervious amounts, things like this. So we are in constant communication with the state about this, who then also works with the federal government, whether that's Army Corps of Engineers, EPA, or Department of Environment. But what this gives us the opportunity to do is the house was not captured previously in MS4 reporting. What was proposed that you saw in 2025 was going to be added to MS4. So this is a unique instance where actually the disturbance and that encroachment is going to go up, but the impervious is actually going down, and it is more accurate reporting. This is the great challenge of all variances, and We hope the third time is the charm for Ms. Bridges here, but this is when you're dealing with floodplain, because we have these reporting requirements and because we have to get this accurately, it is deeply important that we come before you each time to make sure that we have that exact variance so Nancy can get the correct numbers. This isn't one of those things where you can get 100% variance. Well, you could, but that would be a greater challenge. Anything else to add to that, Nancy?
Thank you for that explanation, Sam, and I appreciate the question, too. Does anyone have any other questions for Tyler? And the applicant is not present, is that correct?
Correct.
Great. Is anyone from the public here that would like to give expert testimony or testimony from residents withstanding? Okay, seeing none. Board, is there a discussion or a motion?
Motion to approve variance.
I'll second.
Okay, board members, when I say your name, please say aye or nay. James Warnall.
Aye.
John Michael Cletus.
Aye.
Mike Luciano.
Aye.
Suzanne Godsey is an aye. The revised variance is approved.
Thank you.
Thank you, Tyler. Our next case, the petitioner Lindsay Hamer is requesting a rehearing to a prior variance request to flagpole width standards in section 711 2J 3B, parking, loading, and access standards of the Unified Development Ordinance. The applicant is seeking relief from the 20-foot minimum width for flagpoles within Appendix 7F. The property is known as 5 White Avenue, and the PIN number is 9647940830. And Daniel Fleer, Urban Planner 1, will be presenting this morning.
Daniel, do you mind if I just interject real quick?
I would very much appreciate that.
I just want to read you all the standard for a rehearing and be clear on the procedure for this. This is from your rules of procedure. Our UDO states that requests for rehearing are done according to the board's rules of procedure. So this is all that that's from. An application for a rehearing may be requested by filing a new application and paying the applicable fee on or before the date of the board hearing following the meeting where the decision was made. A rehearing shall only be allowed if the board finds that the evidence in support of the application establishes that there is newly discovered evidence that could not have been, with reasonable diligence, discovered and/or produced at the prior hearing. If the application for a rehearing is allowed, it shall be scheduled for the next board meeting, and it shall thereafter be treated in the same manner as any other application. So today you're deciding if, under that standard, a rehearing should be allowed. You will not decide if the variance should be granted or denied today. That would, if you allow a rehearing, that will be scheduled for your next meeting.
I don't know who that person was.
I don't know what that was either.
I don't know what that was either.
Go ahead, Daniel.
All
Thank you,
right.
Carla.
Hello, everyone. My name is Daniel Fleer, I'm Urban Planner 1 with the city, and to the ends of what Carly was just talking about, I'm just going to give a brief overview of the case as it was heard in June of last year, and then the applicant, Lindsay Hamer, also has a presentation with more of those details towards the ends of a potential rehearing. So, this case is for 5 White Avenue, dedicated to section 711 2J3, which is specifically for flag lots in Appendix 7F of the Unified Development Ordinance. So back in June, there was a request for a 5% variance to reduce the minimum width of the flagpole portion of a lot from 20 feet to 19. This lot is in the Shiloh area, just south of West Chapel Road on White Avenue. And you can see here it is zoned RS8, residential single family high density. And this is a survey showing the proposed subdivision back in June. This lot as is has about 59 square feet of frontage, whereas it would need 60 to create a standard lot and a conforming flag lot. I've just outlined that flag lot in green here for you as well. This is just a quick site photo, and I have the kinds of considerations that we talked about at the time. The existing lot's total road frontage is 59 square feet, while the minimum width for the flagpole portion of a newly created lot is 20 feet, and the minimum width at the street for a standard lot in RS8 is 40 feet. The proposed subdivision would site the existing home on the newly created flag lot to the rear and leave a conforming RS8 lot at the front open to future development. Both lots would adhere to all other standards for flag lots or standard lots as they fit the situation. The board at the time disapproved this request, finding that these necessary findings were not found. I can go back to any slides or answer any questions that the board might have before Lindsay comes up here.
Does anyone have any questions? No. Right, okay. No questions. I think we were all here for that variance, so that's good too. Okay, great. If you want to have Lindsay come up, that would be fantastic.
Sure, I'm just going to pull up the right presentation now. Have you ready up here?
Full transparency, I was prepared to present the entire case, as for actual approval or denial. So I'll be happy to restructure today's talk just to get approval for a rehearing, if that's better. I guess I would, since you guys have kind of heard the city's presentation already, I'd like to start and ask if you guys have any questions that I can answer ahead of time. Sorry, it's so cold.
It is chilly in here. Does anyone have questions for Ms. Hamer before we hear her presentation?
Do you have new information that you did not include in your previous?
Yes.
That would be relevant to the board making a decision?
Yes, I do. So 6 months ago, when I came to the board hearing, I was not adequately prepared to understand, define, or present a hardship at the time. That's absolutely 100% on me. Since then, I have spent some time really understanding the criteria for a hardship, which I'll be happy to present to you. It is different than the last one. There was no hardship at the last one. I will admit that. But I do understand now the criteria. I've also spent time trying to understand the relevance of the new modern zoning laws in coexistence or in alignment with the Legacy Neighborhood Coalition. And from what I have spent time working on, I believe that what we are doing or what we are hoping to accomplish here will actually support that mission as opposed to being in conflict with it. So, any other questions? And I can kind of run through it a little bit.
I would go ahead and run through it.
Okay, thank you. So I am the property owner at 5 White Avenue, and I'm here to request a rehearing for the variance that would allow for subdivision of a flag lot here. This is the home as it stands. It was developed in 1920, over 100 years ago, obviously, long before modern zoning requirements were in place. The historical structure placement of the existing home creates a land-based hardship from what we have determined. It makes it impractical to subdivide the lot in compliance with current standards without minimal relief. So our intent has been to preserve the existing historic structure while allowing for the addition of a modest single-family home as well. That would be in alignment with the rest of the neighborhood. So here's the current status of 5 White Avenue as you see it today. The blue stars indicate 4 other additional flag lots that are already on this singular block of 5 White, one of which has a 16-foot width flagpole. So, and I believe that is the one that you are seeing your bottom right. So, what this really indicates here is that there's already an established neighborhood precedent for this type of configuration, and we are not asking for anything egregious here. We would be in conforming with the rest of the neighborhood and we're only asking for 12 inches. So as, who presented on my behalf? As he presented and showed the survey that we had done, our goal would be for both lots to conform to modern RSA zoning laws. So that's exactly what would happen here. It would provide safe access to both properties. We would maintain the original access. The thing that makes our request unique is that the existing structure is already on what would eventually be the flagpole. So we're not requesting to do new construction on a new flagpole lot. The flagpole lot already exists if we were able to subdivide, and we would be putting a modern single-family home that would fit in alignment with the rest of the neighborhood. One thing I did want to call out that is important to note is that one of the things that came up in the last hearing was that there was a lot of concern, and if you guys remember, a lot of people showed up and talked and had a lot to say. I also was not prepared for that, but I really took to heart what those people had to say, because I'm a local Asheville resident, and my husband grew up here. My father-in-law is currently in VA hospice right now, and they've been living here for over 30 years with small business in this area, actually. So I took what they said to heart, and it really meant a lot to me to maintain the existing structure as it was, and it remains in the existing footprint. This is a mock-up of what the home will look like when it's done. It's pretty much already done, minus the beautiful landscaping. If you were to drive by, it pretty much looks exactly like this picture that you see to your right. So our goal here is not to disrupt the neighborhood. Our goal here is to maintain the character, the style, and also provide another attainable house in the process. I have more information, but I'm going to pause there, again, because I was ready to present this as like an actual approval, but I understand that we're just here to approve a rehearing now, so I don't want to over speak or misuse your time.
So what we're voting on today is to allow a rehearing, and part of that is the basis of new information. So I think presenting it like you would present it for the variance, and that gives us all the information that we need that may be new. So if there's any new information other than what you just shared, I would focus on that. Does the board agree?
Aside from just noting the age of the home and the fact that it was built long before modern zoning requirements were in place, the lot is just honestly not set up to comply to those. So I'm in a position where I have to ask for a variance in order to be able to subdivide. There is no other way to do it. We've met with the city and contacted a surveyor to look at easements, and they're just not allowed in this lot. So we're asking for 12 inches, and that's it.
What are you providing that's different today that you didn't provide?
We did not mention the date or the age of the home in the last presentation. We did not mention that the existing structure would occupy the flagpole lot. We did not mention that we would be preserving the historic nature of the existing structure as opposed to demolishing it and rebuilding it. We did not mention that our goal is to provide another home that would be an attainable home for a modest single-family buyer.
Was that information known at the time? You just didn't mention it?
No. I did not understand, and again, that's on me. I did not understand what a hardship definition was or how to present it. I'm not a legal expert. I'm not a real estate agent. Since then, like I said, I've really tried to be diligent in understanding what the criteria are.
Well, for the rehearing, we have to determine that you did all the due diligence you could, and now there's more information. But it just sounds like you didn't do due diligence the first time, but that's... I wasn't prepared. That's on you. And
Yeah,
not
it was
the-
on me,
yeah.
absolutely. But since then, new information has come to light to me, right? So maybe that information was out there and available to the general public, and maybe you guys knew that, but I didn't know all of this before. So my question, and I wonder if I had presented this information in the original hearing, would the consensus be different? And if there's question of that, then I wonder if a rehearing is on the table.
I mean, it sounds like you're just admitting that you just had a lack of due diligence the first time. And
Yeah, I did. I mean, but it wasn't an intention. It wasn't because I was lazy. It was because I just fully I didn't understand the criteria. And again, I'm not going to sit here and tell you guys that you misunderstood me or that, that's just, It was my first time doing something like this, and if you guys, I don't know if you recall, but there was, from what I understand, it was quite a different hearing than you guys have experienced as well, and I was just not in the right headspace to address a lot of questions, so.
Can I ask the attorney to read the requirements again for us to,
Yes.
thank you.
A rehearing shall only be allowed if the board finds that the evidence in support of the application establishes there is newly discovered evidence that could not have been, with reasonable diligence, discovered and/or produced at the prior hearing.
Could not. Right.
So when I hear that, I hear there was a water line that was discovered that is preventing some type of hardship, not necessarily just explaining more information about the existing application as it came through before. I heard that it was a historic house, that it's remaining, that is new information. The question is that information pertinent to the granting of a variance?
The question is also whether it could have been discovered prior to the first hearing with reasonable diligence. So is
Was
it
that reasonable
something,
diligence on our part? I mean, if we look at the street view, and we look at, tax maps, and we see when the house was built, sometimes that's mentioned in the staff report in of itself.
yeah, I mean, the burden is really on the applicant to provide all the evidence in support of the variance request. And she's the one who's making the request, so she has to demonstrate that there's evidence that could not have been discovered at the time of the first application. Yeah.
Thank you, though, Carly, that's helpful to hear it read again, and also to listen to your explanation. Does anybody have any questions of Ms. Hamer? Do you have anything else to share, or?
It's worth mentioning that, again, the new lot would align to the intentions of the RSA zoning, right? So we're allowing the development of a single-family detached home. We want to maintain neighborhood character and scale, promote compatibility, and also, like I said, we want to make sure that we're adding to the quantity of affordable housing that there is in Asheville. The existing structure is preserved, safe driveway access remains, utilities, it conforms to the lot requirements, consistent with the neighborhood pattern, again, the 4 existing flag lots that already exist. So this really isn't asking for anything egregious, in our opinion. So I have nothing else that would qualify, I guess, as additional information, just kind of double-clicking on some points that I think matter.
I've got a question. Okay, maybe for the staff. Is the lot that's derived from this approval, if pending approval, is it buildable? Is it permittable?
That's kind of a loaded question. So it is not pending approval. This has to happen for this to move forward. There are standards for RS8. It has to be, we have our building envelope, which has to be 15 feet from the front and rear and 6 feet from the sides. We have found smaller lots. I have admitted this at PZC and TRC and council. I will say this to this board too. All the good flat lots are taken. All the large lots are taken. This is the remaining lot inventory in Asheville is challenging. Is it buildable? That is kind of a subjective thing. There can be a structure that can be placed on it that meets minimum building code standards. Is that, does that meet the needs of today's housing? I can't speak to that, and really that's also not my place. But it is something where it could be a viable lot where a structure could be placed, and I can answer that.
Can we bring up Appendix 7F again and talk about, I know you want me to, and give the board a little bit of information about when that went into effect and how that does or does not affect this property?
Again, I will give a short answer. There is a tremendous amount of nuance here, but in March of 2025, as part of UDO text amendments that were passed, which included reducing and eliminating parking minimums in certain transit-oriented corridors and changing sort of the review level thresholds as an enticement to keep things below the council level. Staff had worked with local developer Barry Bialik for sort of two other things, which were cottage clusters and flag lots. At the days during the council meeting, there was some compromising concern about preservation of character for legacy neighborhoods, which are integral to the character of Asheville writ large. And so what had come out of those negotiations was the confusingly named 7F. So this was not a map amendment like most other overlays. This was a text amendment. So there were all PIN numbers within the 5 legacy neighborhoods and also areas identified by the Missing Middle Housing Study as being vulnerable to change. So any lot that was within that area has a PIN number. Those PIN numbers were written down. So here's a unique thing. If you subdivide one of those lots, you get a new PIN number, which takes you out of 7F, and is therefore no longer under the same standard of review. Now, these other 7F lots that I just described, those do have different standards than the rest of the city for flag lots, including flagpole width. This must meet the required 20-foot flagpole width, which the applicant is seeking a variance from. And then there are also other standards in terms of size and things like that. So this is to preserve the character of those legacy neighborhoods in those changing areas. And that tended to present itself with flagpoles and cottage clusters.
So in relation to the flagpole width, if this piece of property was not in 7F, identified by PIN number, the flagpole width could be how wide?
16, I believe. Let me confirm that real quick. I haven't,
I think that's right.
yeah, Daniel does more flag lots than I do these days.
Yes, broadly speaking, 16, though, because this would potentially be sharing a driveway with its parent parcel, it could be as low as 10 feet wide.
So we talk about ordinance and how the UDO is such a dinosaur and it's so out of touch. This is an amendment that was made in May of last year.
March, but yes.
March of last year. It's not an out-of-touch amendment. I mean, it's brand new, and the city has specifically identified that they want to preserve and limit development in legacy neighborhoods by including parcels in Appendix 7F.
Correct.
We went under contract for this home in March of last year, so we were not aware when we went under contract, and when we closed, we weren't aware as well. After the lot was purchased and we started to go through this process and look at subdivision, that is when we determined and understood that the variance would be required. That said, because of the way that this structure, this lot was developed back in 1920, there's no way that it could conform to that. So the only way for us to be able to subdivide is to do a flag lot, or I'm sorry, is to do a variance request. One other thing of note, I don't know if it matters or not, but if you look towards the end of 5 White towards your right, there are 3 lots that have no structures on them. Those have been developed with new construction by a developer. And those houses, those lots are very similar in size to what would be the subdivided lot. In conjunction with that, the builder that would be purchasing this lot from me is that builder that has developed on this street already. Again, further, hitting on the point that we are trying to be in, like, we're trying to conform with the neighborhood. We're not trying to do anything out of ordinary. And the whole purpose behind the 7SF and legacy neighborhoods is to allow for, attainable housing and avoid people coming in and making it impossible for the legacy neighborhood to exist as it was. And so again, like we want to make this happen in conjunction and in alignment with that, not in opposition to that.
Does anyone have any questions, any additional questions for Ms. Hamer or staff? And should we open it up for the public?
We also believe the lot is buildable and the driveway would not, and we would be able to have a separate driveway with access to the home for the residents and for emergency vehicles.
Before we open it up to the public, if it's not too much trouble, could you please identify the paragraph number in the UDO with the requirement for the rehearing that you?
So it actually comes from the rules of procedure.
Oh, gotcha. Okay,
Let
thank
me
you.
find the exact section of the rules of procedure.
I think that's going to be difficult for me to find and bring up right now. Just those words matter very much, and
Yeah.
just thought I might take the time to. Perhaps one more time then
No problem.
would be helpful for me.
Okay, so this is section 7D of your rules of procedure, titled Rehearings.
Of the like 2018 or the new that was approved today?
It should be the same in the new one. I guess I was looking at the old one because that's what
That's
I had
okay,
saved.
I've got the old one
But
up.
it should be the same.
Hearings.
The larger section is titled Hearings,
Yep,
and then in
And then subparagraph, which one is it?
D,
Thank you very much. Very good.
and just again, that standard, a
Got it.
rehearing shall only be allowed if the board finds that the evidence in support of the application establishes that there is newly discovered evidence that could not have been, with reasonable diligence, discovered and/or produced at the prior hearing.
Thank you very much. That's helpful. Ma'am, I think you wanted to open it up for public comment?
Yes. So thank you, Ms. Hamer. You can sit down. If we have any other questions, we'll call you up. Is anyone from the public here that would like to give expert testimony or testimony from residents with standing? Come on up, Mr. Moritz.
And so, you all are familiar with the standard for standing. Those who apply for standing have to demonstrate they'll suffer special damages as a result of the application. That's pretty narrow in this case. This is a request for rehearing. So somebody would have to demonstrate that they would suffer special damages if a rehearing is granted. Of course, the chair does always have discretion to allow testimony from those who do not have standing. So, yeah, that's the standard.
Okay, so let's determine whether or not you have standing.
Good morning,
Will
Chairwoman
you state your
Gotze.
name first?
My name is David Moritz. May I establish standing as an expert? I understand that that's one of the criteria for establishing standing. I'm an engineer and a developer. I have a master's degree in real estate. I have 30 years of real estate experience, and I have 12 years of experience in land development in the city of Asheville. I'm an expert in zoning, have spoken for 7 years on zoning at city council, and I participated in this particular text amendment, and so I believe I have expert standing.
So you can ask questions of Mr. Moritz to determine if he is an expert and can provide expert testimony. Standing is sort of separate and apart from that. So that would be more along the lines of inviting testimony from somebody who can provide relevant expert testimony. Typically, parties with standing will produce an expert to provide expert testimony in support of the application. And so I would say that if somebody wants to speak on this matter and provide expert testimony, then that would not so much be a standing analysis, and that would be in the chair's discretion, allowing testimony at the hearing. And to be expert testimony, somebody has to demonstrate they have specialized knowledge and experience on a subject. And you may ask questions to determine if somebody is an expert.
Well, just by your training and your expertise alone, I would say that you're pretty close to being an expert to provide information to the board. I don't really want to make this decision all amongst myself. Is the board willing to hear what Mr. Moritz has to say in relation to, would he be focusing his testimony on new information regarding the rehearing, or?
Yes, to be relevant to this hearing, whatever testimony you provide has to be relevant to the question of whether there is newly discovered evidence warranting a rehearing. If it's relevant to whether a variance should be granted, that is not relevant. That would be more appropriate.
I do want to make some statements to correct some things that have been said regarding the UDO, based on my expertise on the UDO, that were said that may have influenced the committee.
May have influenced.
If you would allow me.
What
to
was
do
that?
so. If you would allow me to do so, I'd like to correct some statements that were made regarding this application that are directly relevant to the UDO and my expertise in it.
Is it relevant to whether the board should grant a rehearing?
It's relevant to the information that they were provided that could influence them in making the decision, yes.
Okay.
If you have information about the UDO that is pertinent to this case, I'm inclined to listen to it, so.
Okay.
If everyone is okay with that?
Suzanne, I'd like to make a comment.
Yes, please.
Yeah, for me, it's what is your experience with this particular aspect of high density in Asheville?
With what?
Urban plan, or just, this is a high density urban planning issue for me, but maybe I'm mistaken. But where do you bring that expertise?
I'm a land developer in Asheville that has developed small lots, big lots, many lots, and I focus very closely on the UDO, and I have expertise in it.
Okay.
So the board can hear Mr. Moritz's testimony if it finds it relevant. It sounds like maybe this is more appropriate as an invitation to provide witness testimony rather than an application for standing. So, Mr. Moritz, are you comfortable providing witness testimony and rescinding your application for standing as a party? Or the board will have to vote on
What's the
whether
criteria
that's...
so I can...
Yeah, okay. Because if you're comfortable with that scheme of providing just testimony, then, because otherwise the board would have to vote on your application for standing. But if you no longer want to apply for standing specifically and just want to provide some witness testimony, then, okay.
I want excluded this parcel and other parcels in the city from the new text amendment, and any change to that would be a material contradiction of the legislative intent of the UDO itself. Second, I don't believe the applicant has shown any hardship or any change since the last application. There was nothing specifically said that warranted any change to the decision that was made based on the information that was provided. And these lots that have been specifically excluded from the change were done so for a variety of reasons, including public safety, access, circulation. This neighborhood has very narrow streets, and so forth. And changing that would set a dangerous precedent that contradicts a long legislative process that was undertaken to achieve this specific outcome in this neighborhood. And I did not see any new hardship. In fact, the house that's currently there can be renovated and sold, so there is actually no hardship. The other thing I would say, just to correct the last statement here, that the property was under contract in March and closed in April. If it was in March and the text amendment hadn't been done, then all properties in the city had a 20-foot width flag lot requirement already. And so the idea that the applicant was unaware of that is not an accurate statement according to the UDO at the time. And then the text amendment actually specifically kept the 20-foot requirement for this lot. So just wanted to make sure that we stick to the UDO language and not speculate as to the history of it. Thank you.
Thank you. Is there anyone else in the public that would like to give expert testimony or testimony from residents with standing? Okay, seeing none. Board, is there discussion or a motion?
I just don't think it's just lack of due diligence the first time isn't a reason to grant this. There's nothing, I didn't see anything new that shouldn't have been known the first time.
I also did not hear anything new that would warrant a rehearing. Mike. Oh, well, I wasn't making a motion. I was just making a declarative statement. Thank you, though, Mike. You may see if Mr. Warnall has any comments, and if he doesn't, you may make a motion.
My comments are the same as yours.
So with that, may I get a motion? You can do this, people. I know we're cold.
Make a motion, I beg your pardon, motion to not approve the request for a rehearing of this variance.
Deny the request for a rehearing.
Yes.
Okay, may I get a second?
I'll second the motion.
Okay. Board members, when I say your name, please say aye or nay. James Warnall.
Aye.
John Michael Cletus.
Aye.
Mike Luciano.
Aye.
Suzanne Godsey is an aye. Okay, our next variance is petitioner Suzanne Lowe, represented by Miller Graves, is requesting variances to the setback standards in section 710-2C, required setbacks, allowable encroachments into required setbacks in section 784F5 RS8 residential single-family high-density district setback standards of the Unified Development Ordinance. The applicant is seeking relief from the required front setbacks for a corner lot, and the property is known as 57 Craggy Avenue. PIN number is 9638-066513, and Madeline Stone, Urban Planner 1, is presenting.
Thank you, Chair, Commissioners. Madeline Stone, Urban Planner 1, Planning and Urban Design Department. Today we're going to be looking at 57 Craggy Avenue. The applicant is seeking the variance for the standards found in Section 784 of the UDO, which is for the setback standards, which have a front setback of 15 feet, a side setback of 6 feet, 7.5 corner side setback, and a rear of 15 feet. The variance will allow for a 32-inch encroachment into the 7.5 corner side setback. The parcel we're looking at is 57 Craggy Avenue. It is on the corner of Craggy and Pinellas Avenue. The request for the 32-inch encroachment would be a 35.6% variance. 57 Craggy and surrounding parcels are all zoned as RS8. The subject parcel is 0.16 acres. It's located in West Asheville between Patton Avenue and Haywood Road. All adjacent lots contain a single-family dwelling. The lots on Pinellas and Craggy Avenue were created in 1921. Pinellas and Craggy Avenue are served by a 50-foot city-maintained right-of-way, which is greater than the commonly found 30 to 40-foot right-of-way. The platted property line is located significantly farther away from the actual edge of pavement than is typical in similar residential areas. The proposed addition will remain 28.6 feet from the edge of pavement. If the property line were located close to or at the edge of pavement, as is functionally the case in many neighborhoods, this structure would exceed the 7.5-foot corner lot setback. There's a photo from the front of the home, the side of the home looking at Pinellas Avenue, and another one from the front. Here is the site plan provided by the applicant. As you can see, the addition will be on the left side of the home facing Pinellas Avenue. It's going to be about 2 feet, 8 inches variance. The proposed addition is 233 square feet, and it is going to be 28.6 feet away from the road. There's a site plan. The addition is going to be for a kitchen, and then on the right you can see a rendering of what the addition will look like. This is also provided by the applicant. It's showing the properties in pink have less than 28-foot distance from the home to the edge of pavement in the RS8 zoning. Some considerations: the requested variance is for 32-inch encroachment and the required 7.5 required corner side setback. The addition will be 28.6 feet from the edge of pavement. The lot was platted in 1921 with a 50-foot right-of-way. The combination of the lot configuration and current zoning regulations create additional development constraints. And neighboring parcels have homes positioned closer to the road than 57 Craggy Avenue. If the proposed addition were located at the front of home, Section 710(2) of the UDO would allow for adjustment to the building line without requiring review by the Board of Adjustment. I'm happy to answer any questions. The applicant is here to answer questions as well.
Does anyone have any questions for Ms. Stone before the applicant comes up? Questions? Okay. The applicant would like to come up and if they have a presentation or additional testimony for the board to consider.
Hello, thank you. The one thing that I do have to add is a letter that was not notarized, so it's not part of your packet, but was given to the owner, that basically says that they support their next door neighbors, writing to express support, and specifically I support granting the requested 3-foot setback variance, 32 inches. This minor variance is necessary for the planned renovations and for and as her next door neighbor, I am confident it will not negatively impact us, other neighbors, or the neighborhood as a whole. The renovations she is planning are consistent with the look and feel of the neighborhood and modernizing older homes helps keep them relevant and maintain neighborhood property values. So that's basically what we're going for, is to add a kitchen to a little old house that would love the love of having a new kitchen. You can see that, I guess if I go back here, looking at the corner of Craggy and Pinellas, you can see those dots are the edge of the property line, which is a massive right-of-way there on Pinellas, on both. And so the distance from the edge of the pavement to our new addition would still be 28'6", which is considerably more than many, obviously, other properties in the neighborhood. Specifically looking at the corner of Blue Ridge and Craggy, all three of those big old lots with houses, which are real historic, all sit closer than 28'6" to the pavement. So it's very much in the spirit of the neighborhood, and we're confident it will be a great project, upgrade the house.
And just for the record, will you state your name, please?
I'm Miller Graves.
Does anyone have any questions for Mrs. Graves?
Just curious, was that next door neighbor on the Pinellas Avenue side or the Craggy Avenue side? Okay, thank you.
Could you toggle over to the architectural site plan or your architectural footprint? No, back one more, or back forward one more. There we go. Mhm. So is that the location of the existing kitchen as it stands today? Or are you redoing the entire floor plan?
The kitchen as it stands right now, you can see the back door, right, in that, in the back of the house. That back door goes into the kitchen, and where the bedroom is on the back right corner, there's a window right behind the bed, and then in the center of the house, there is a window. That window is currently in the kitchen, and it is as deep as basically that closet wall, so it's like a 4.5-foot deep kitchen running along the back of there. It is a very incredibly awkward space that has been created over the 100 years that desperately needs an upgrade.
So it's at the rear of the house currently?
The front kitchen is basically where those two back-to-back closets are. That's the kitchen.
Oh, okay. And then what is behind the house? I can't read it. It's like a covered deck.
There's a little covered porch back there, and then an open deck and stairs to go into the backyard.
So in addition to adding on this kitchen, you're just overall improving more of like a open floor plan for this house that was built when rooms were really chopped up and kitchens were really small. I lived in a house that was built in 1927, so I understand this floor plan very well.
So basically, we're just taking the old kitchen space and letting it become a rear entry and just giving more space. There's a pantry, a coat closet, another closet for the bedroom, and a nice modern kitchen.
In looking at a hardship for a variance, and looking at, definitely the site itself has some constraints with that side front setback and an extra wide right-of-way, so it's gonna give that appearance. But from a floor plan perspective, is this floor plan, when you're arranging pieces and parts of floor plan, you've got distances between like clear distances, and you have to open the refrigerator and all of those. When you were looking at your space planning of that space, were you trying to make it as concise as possible to stay within that setback, and you just can't functionally place all of those features of a kitchen? Like, is this the minimum area that you would need?
So, yes, and part of it is also structural. So we had discussed having a much more narrow addition, but we talked about taking away that part of the existing left-hand wall to get there, to have a big open space, which we deemed much too expensive and difficult because of the brick veneer that's above it, that holding all of that up by taking all of that existing away is too much. So what we're doing is leaving that wall, and the cased openings that go into the kitchen are existing. There's an existing French door right off the dining room, and there's an existing window, both of which will be removed. So those casings are there, that structure is there. We're not changing anything of the structure of the existing exterior brick wall. We're just adding a kitchen, and the depth was desired in order to have a family kitchen where there could be a narrow island but have seating and have flow around it instead of that being pushed against the wall and made so that the addition is worth it. In order to spend the money, those extra 32 inches really create a space that has flow and is worth spending that amount of money to have exactly what the owner would really like to have.
Does
Which is
anyone,
a family kitchen.
does anyone have any other questions for the applicant? No? Okay. Thank you, Ms. Graves. We'll call you back up if we have any other questions as we move through. Is anyone from the public here that would like to give expert testimony or testimony from residents with standing? Okay, seeing none. Board, is there any discussion or is there a motion?
Motion to approve the variance.
May I get a second?
Second motion?
Board members, when I say your name, please say aye or nay. James Warnall.
Aye.
John Michael Cletus.
Aye.
Mike Luciano.
Aye.
Suzanne Gotzi is an aye, and the variance is approved. Thank you. Thank you. Have a good day. I believe this might be our last variance, so in record time, the petitioner, Pierce Harmon, on behalf of owners Arthur and Angela Hickson, is requesting a variance to steep slope and ridgetop development standards in section 712.4F1, steep slope and ridgetop development of the Unified Development Ordinance. The applicant is seeking a variance to allow extra land area of disturbance in order to install a septic system for a proposed home. The property is known as 99999 Windswept Drive, and the PIN is 9648799066. And Daniel Fleer, Urban Planner 1, is presenting.
Speak to you again. Just one note, the quintuple nines are just essentially a placeholder address when a parcel does not have an address. All right, so we have the petitioner Pierce Harmon requesting a variance to the grading extent limitations that are found in section 712.4 F1, which is dedicated to steep slope and ridgetop development. The applicant is seeking a variance to allow extra land area of disturbance in order to install a septic system for a proposed new home. The existing parcel is undeveloped and does not have access to sewer facilities. So due to the elevation and the slope, steep slope 712.4 limits the grading extent to 15% of the parcel area. In this case, with a total acreage of around 1.7 acres, that 15% is 11,500. The applicant proposes to construct a single-family home with a swimming pool and a septic system. The project as proposed will require a grading extent of 12,900 square feet and 9% variance. And so just for some site context here, you can see this is just on Bowcatcher Mountain, a little bit southeast of downtown. Here we see a zoning map showing that this is RS2, which is our least dense single-family zoning. And then we have a little bit of more specific context in terms of not much is developed on this side of Windswept Drive, though we do have 3 homes more directly adjacent to the relevant property here on the opposite side. Both 100 and 300 Windswept Drive, their properties actually extend across the street, so the properties directly to the north and south are on the same parcels as 100 and 300 Windswept Drive. So the subject property is a 1.67 acre residential lot currently zoned RS2. It is surrounded by residential lots, and all adjacent lots on its side of the street are undeveloped. And I already clarified that one point about the lots directly to the north and south. So with a maximum elevation of 2,560 feet, this parcel is in steep slopes zone B. It has an average slope of 41.58%. The code permits this parcel a maximum grading extent of 15%, which comes to 11,500 square feet. The proposed grading extent for this project, excluding the work done to allow for the septic system, is under that threshold at 11,406 square feet. And I'm told this includes both the single-family home, the swimming pool, driveway, as well as some allowance for landscaping as a part of that as well. The installation of a septic system will require approximately 1,500 square feet of additional site disturbance for a total of approximately 12,900 square feet. I'll go through the site plans as well as some elevations for this home. It has a 1,873 square foot footprint with a building height ranging between 29.5 and 37.75 feet relative to the grade, because as you might imagine, this is on a fairly steep slope down from the Windswept Drive. Plans also include a 448 square foot pool and associated deck and patio areas, while the proposed driveway is approximately 150 feet by 10 feet and shall be supported by the development of a retaining wall up to 6 feet in height. So the property actually extends a little bit further to Plan East here. We see the driveway coming up from the northwest, Plan Northwest side of this parcel. And there are 2 or 3 elements that I want to call your attention to here. So directly south and then to the east of that area, we see some of those septic systems in process. And the septic tank, I believe, is shown actually just to the right of that septic field. This just reiterates some information that I spoke on before, but just one additional note here. The gross floor area for this home is approximately 5,250 square feet.
Sorry to interrupt. Is it going up from the house or down from the house?
It's going down from the road.
So like where the pool is, it's going downhill?
That's correct.
Okay.
And I do have some, not that they're particularly elucidating because this is an undeveloped parcel, but I do have some site photos to kind of give you a sense of what this property looks like from the road. So this is a slightly zoomed in image of that septic field and septic repair area. These outlined areas dedicated to septic are not the grading extent necessarily, because the actual grading required to install the septic system is far less. So just to reiterate some of these points, the extent of grading during and after development is limited by the steep slope ordinance to 15% of the lot area, While the conceptual design for the home, driveway, pool, and landscaping falls below this requirement, installation of a septic system would drive the grading extent approximately, and this is I made an error on this section, it's only 9%, it's not 65%. The proposed project is unable to access Metropolitan Sewerage District sewer lines, and the applicant will be able to speak a little bit more on that point because they have demonstrated an effort to connect to those sewer lines. As new development in steep slopes Zone B, this project shall be preservation ordinance found in Article 19 of the Unified Development Ordinance. The proposed project would adhere to all other standards in the UDO. And so if I were to go back to that site plan, you will see that they have all the trees that they intend to preserve in perpetuity outlined on the plan. And just to presage what the applicant is going to come up here in a minute and talk about, the petitioner notes in their application that existing sewer lines shown on the property and a survey during the property purchase were thought to be usable for the single-family home, but MSD will not allow this home to be connected in this way. So here I just have some elevations. This really helps you understand kind of the orientation of the home as it relates to the street. And you can see that swimming pool to the back there. And I can return to these as necessary. And this is a photo of what the site looks like, not now, because it's way too green, but in the summer.
I wish that picture was taken today.
I believe just a reiteration of the findings. A necessary hardship would result from the strict application of this ordinance. The hardship results from conditions peculiar to the property, such as location, size, or topography. Hardship did not result from actions taken by the applicant or the property owner, and that the requested variance is consistent with the spirit, purpose, and intent of the ordinance such that public safety is secured and substantial justice is achieved. That is the end of my presentation. I'm happy to move around the slide as necessary, but we do have the applicant here to answer any questions for them.
Before they come up, does anyone have any questions for Daniel at this time?
Suzanne, I've got a couple, Daniel. What's the plan to access the septic system at that steep a slope for maintenance, or I don't know if it needs pumping or whatever?
The applicant will be best able to answer that question, so I'll hold off for them to answer that.
And then the survey that the applicant relied on, did it show the MSD connection or a line?
That is my understanding. Again, they were probably better able to speak on that, but my understanding is that a survey showed those sewer lines, and then upon trying to use them, they were told by MSD that they could not.
But is it, okay, so we'll ask the applicant, we need to know, or at least I need to know that indeed the MSD denied access to the line, or is it an issue of how far the line is away and cost to put it in, or there seems to be some extraordinary issues here.
Those are good questions for the applicant.
Yeah.
You're right.
Yeah.
You are right. Okay, so no more questions for Daniel. So if the applicants would like to come up, if they have presentation or additional testimony for the board to consider.
And actually, Madam Chair, before any of them do any of that, all three of them came in after the initial swearing in, so if we can reaffirm. Oh, okay. Well, you were furthest in the back, so I didn't see it, yeah. You get to do it twice today.
Okay, let me find. Okay, if you will stand and raise your right hand. Anyone that is going to speak. Do you solemnly swear or affirm that the evidence you shall give to the board and this action shall be the truth, the whole truth, and nothing but the truth? Thank you so much.
My name is Pierce Harmon, and I'm with River Birch Builders, so I'm representing our client. This is Arthur or Al Hickson, the property owner.
Fantastic. It sounded like there were some questions from the board about this MSD sewer line and lack of ability to connect to it.
Yes, it was the understanding of the clients when they made the property purchase that there were actually multiple 4-inch PVC sewer lines that were running through the property that were inspected by plumbers, and deemed to be functional and in use. But during our kind of exploration with MSD and doing pre-construction sort of due diligence for the, just for getting the utility connections, we realized the MSD was not going to allow them to tie a new house onto these, even though they do carry neighboring homes that are just, it seems that they have undocumented sewer taps that are still functional. So, rather than try to, basically MSD was saying that they felt like they were at capacity because the connection would be downslope from the new home, and it's kind of near the Ardmion apartment complex. And from the MSD side, they kind of came back to us saying they felt like the load calculation was too high to even add one more single-family home onto those lines.
Did they give you an option, like, or
Nothing.
they just said denied, or?
They're not.
Okay.
And so one of the things that, obviously came up in discussion was like, well, how do we figure that out? Because there wasn't an easement in place. We don't know what year these sewer lines were run. So if they're grandfathered in they are still in function, and, kind of thought maybe the best path forward would be to pursue the septic and leave them intact and let them continue to have the sewer service that they're already connected to, rather than trying to renegotiate something that was going to be, really a hassle for the other neighbors and cost prohibitive for everybody involved to extend the sewer line up Windswept Drive.
And even if they installed it up Windswept Drive, you'd have to pump up to Windswept Drive. So do we know how far up MSD line goes on Windswept Drive?
So basically let's go to the north and the south following Windswept. It's about an 800-foot sewer line extension from one direction and about 650 or 700 feet from the other direction. So it's substantial cost involved, big disruption to the neighborhood. We're only trying to put one house on it, and everybody else is connected, so we kind of felt like that was a lot of disruption and a lot of cost if we could avoid that. And also too, to your point, the pump system for the home would be, it's not ideal, but it would, that could work, but
not
we
without
also
the
are
sewer
lifting
line
at like
extension.
2 levels. It's not just lifting, 6 or 8 feet. We've got to we're so far down slope to get the footprint of the house in that we'd be lifting like 20 feet or so, which is that's a big ask for the sewer pumps.
Do you have written documentation from MSD stating the conflicts and
I probably have an email for that.
concerns?
I think at this point, we've met them on site a few times, different representatives, different kind of, people that have different roles there, and they've come out and just, when they've run it back up the chain of command at the office, it's basically just been squashed for us to get to it. And so
Including that in your packet would have been really helpful, because that
Okay.
sort of puts a nail in
Yeah.
that opportunity, which is why we're here,
Yeah.
basically. The septic is causing the need for a variance.
Right.
So if you're being completely denied access, or it's incompatible for them to, so if you have that, I don't know if you can find it on your phone, if that's
take a look
something
real
that
quick, yeah, if you guys
we
have
could
it,
look at. I would like to look at it. I don't know about anyone else on the board. So see if you can find that.
Does the city know do you guys know if that was the case?
Staff can corroborate what he's saying.
Okay.
Yeah.
Okay, thank you. That
I was
is
gonna say, they
helpful.
probably
So,
did that, yeah.
this is just a general question for those lots that are up there. Are they all going to need to have septic now?
That's, this is the fun thing. I come into work on Monday with a plan for my week, and then I find a problem, and then my plan for the week goes out. This is one of those examples of the things I didn't think we would have to coordinate and resolve. It may be, again, from all my previous presentations, the good flat lots are taken. All of them are going to have a challenge. This is going to be a challenge, we think. I will say that next week marks 5 years here for me. In my 5 years of being here, I've never seen this, which speaks to slope severity and perhaps the uniqueness of the challenge too.
And when we see this typically, and I know that the county is irrelevant with the city, but typically for the Buncombe County, they don't factor in the septic area as being part of the disturbance, but in the city with the UDO and stuff, it looks like we do have to consider that, and we're trying to get our calculations of disturbed area down, just to see if we could try to fit this, but just getting like the auto court and being able to turn around, you know, the home is actually kind of a smaller amount of the footprint of the actual house is a little, is you know, 2,500 or something for the area of just the home, but then the nature of getting the driveway, the auto court, and the usable like patio and pool deck area in there, that's what's kind of running our.
Right, I mean, when you take a look at the site plan and on these steep slopes, so I'm a landscape architect, so I see the methodology of what you had to do to get a home benched in there. I was looking at, you know, well, a home is a need, a pool is an ask. When you look at the overall disturbed area, even eliminating the pool, you'd still be asking for a variance, so I was kind of working through that in my brain. We are a vehicular dependent area, so you have to have cars, you have to have a way for them to turn around, and you have to have a way for them to turn around and not hit any retaining walls or the house, or so there's some spatial requirements there that are, it doesn't look like that's egregious at all in your site planning. Looks like you have this as compact pretty much as you could possibly get it as I'm just looking at it. So really having to add the septic to your impervious surface to the most restrictive zoning district and the most restrictive steep slope district, you are hemmed in quite a bit with what you can actually disturb. So I understand the challenges there. Does anyone have any questions for the applicant?
Yeah, what about maintenance access? He had asked that earlier and just.
So we're kind of trying to get through this hurdle first, but I think that we would be able to, I think that they would be able to reach the tank. I'm not sure how to navigate this, but, so can you see the septic tank there off of sort of the northwest corner of the patio area? So the idea of putting it there would just be that whenever they came to pump, they would be able to get the service truck to the auto court and reach it, you know, with pump lines to clear the tank. And I think if, you know, in the event that some lines needed to be replaced or repair needed to be made there, they would, you know, their access would just have to be made for the piece of equipment to get down there. And this area too, one of the things, so with the red trees, you know, most of those are already blown down from Helene, so a lot of that, like where we have the lower change in grade or the sort of flatter area that's naturally less slope on the property where we're trying to place everything, a lot of that's already kind of been cleared, you know, from the winds and stuff, and so we are going to be coming down there with equipment to clear up all the fallen timber and stuff too.
What's on the other side of the lot, like downhill from the septic?
Downhill from the septic, there's a big buffer area, and then that's
Not a community swimming pool.
no, I think we've got enough.
Question.
Yeah, it's a good question.
Yeah, I mean, just like what's downhill from the septic, like what is there? I don't know.
It's a bunch of, it's just, so you can kind of see the property line at the bottom. It's going north to south kind of on that, with that angle, and it's below that is, I'm pretty sure there's just like a big, it's like a big patch of woods before we get to the Arbion. It's called Arbion Park Apartments on the sort of closer to the hospital side, and then I think it's just undeveloped above. There's a bunch of woods. Yeah. So this one,
Oh, sorry, is it okay? So the subject property is like on the hill, like right above the Arbion Park, like the old Sky Club.
It's not that one. It's like these are more like the condos, not the one that was you know
The famous one.
Yeah. That one's a little further down, but there's another one. It's got a similar name. It's Arbion.
So this lot, like, it's helpful for me, like, to picture it on the hillside back over there. Is it?
The Arbion Park, like the old supper club or
Yeah.
whatever it's called, that was further north. I think it's close
Okay.
coming back towards downtown.
This one's further south.
Yeah.
This lot's further south from that. Okay, good. Do you mind? I'd have just like one or two more. Is that okay? I didn't mean to interrupt. Going back to the site plan where you had where you could see the house, the pool, and there we go. Just below, downhill from the septic field, and around it, like, I'm just curious, visibility speaking, from down here in town, looking up there, is on the lot, would that, I'm not an expert in septic fields and construction, you gotta clear that, like, is it gonna be flat graded and flattened and all that, or is there gonna be trees and stuff like that from down here that in any way would obscure you from looking up and seeing that big septic field?
So, yeah, so the requirements for the septic installation are gonna be that it has to go on contour. So this was kind of just superimposed here. It's never a straight line, so we kind of have to follow the contour of those topo lines, right?
Yeah.
And we're only disturbing, we're digging a 3-foot trench at a time. We're not coming in and grading anything. We're actually just digging a 3-foot trench on contour, and that's where the diffuser lines are gonna go for the drain field. So, and then each of those, basically, typical system is gonna be a 3-foot ditch. They're 9 feet on center, so you have enough room to run the machine without fully disturbing everything. You know, we pull all that up, we have it inspected, we put it back within a couple of days, you know, so it's, and this is we kind of went a little big on just showing this field because the folks at Environmental Health had already said there was no problem for this. We just haven't requested like a construction authorization for them to get the final design, so we want to make sure we've got approval before we go through that.
Okay.
So you've gone conservatively in showing those lines and what you need in order to facilitate a septic system.
Yeah, that's right. For 4 bedrooms, we need about 75 linear feet of drain line per bedroom, so it's only about 300 linear feet. If we did that in a few lines and followed contours.
Did you, I don't know if you guys allow this in the city, but have you ever allowed someone just to come in and do the 3-foot trench, 3-foot trench, 3-foot trench, 3-foot trench, and just calculate that area instead of just the overall, all of the septic in and of itself? Because as he was saying, it's not the whole thing is not being graded. It's a trench that's being installed. So there's areas between the trenches that are undisturbed.
I can.
You go for it.
I can speak briefly to this. I think that's at least partially already been calculated into the 1,500 square feet. The reason why I had that error of 65% is the total of the 2 septic areas shown on the plan is about 6,000 square feet, but only 1,500 of that is actually being included in the grading extent here. One thing I'll just note while I'm here is that you may or may not know, but septic systems are permitted separately. This is not an approval for a septic system by any means, but they are permitted by Environmental Health with Buncombe County. It is not a city review for that process.
I need not follow up, Daniel, but I will anyways, just for some BOA notes. I think it's important that I not just speak to you, as you heard from 30 Lodge Street. I think it's important because a lot of people are watching to sort of explain these processes and why we do what we do. As Mr. Harmon had alluded, he was using conservative estimates. We don't want a situation where an applicant keeps coming back, say, for example, 3 times like we had seen earlier today. So this is, while it is probably less disturbance than what we will grant a variance for, this presents us from consuming staff time and resources and yours as well.
That makes sense. Does anyone else have any questions for the applicants right now? No? Okay, if you guys would like to sit down, and we'll call you back if we have any other questions. Is anyone from the public here that would like to give expert testimony or testimony from residents with standing? Okay, seeing none, board, is there discussion or is there a motion?
Motion to approve the variance.
I'll second.
Okay, board members, when I say your name, please say aye or nay. James Warnall?
Aye.
John Michael Cletus?
Aye.
Mike Luciano?
Aye.
Suzanne Godsey is an aye. Variance is approved. Okay, is there anything else that we need to discuss? All right, if there are no objections, are there any objections? We can adjourn this meeting.
Thank you.
No objections.
All right, meeting's adjourned.
Thanks for your time, y'all.
Thank you guys so much.
It's just now starting to get warm.
I know. I was like shivering.
I have to walk. I know John Michael's like, I'm